Welcome to this video on mapping the Digital Personal Data Protection Act with the GDPR. We will explore a granular section-by-section crosswalk between the two frameworks. While the previous video compares the two regulations, this video maps the section and subsection of DPDPA to articles of GDPR for further understanding the differences and similarities between the two. Both the DPDPA and the GDPR are comprehensive data protection regimes, though they differ in their legal structure, granularity, and operational philosophy, while sharing a common goal of protecting individual rights. Mapping the applicability and scope of these two regulations can be done by comparing Sections 1 and 3 of the DPDPA with Articles 99, 2, and 3. DPDPA is limited to digital personal data and digitized records, while GDPR is broader. Section 1.2 aligns with Article 99. Section 3 covers extraterritorial scope, similar to GDPR Articles 2 and 3, with strong alignment seen in Section 3C and Article 3.2. Next, we look at the definitions crosswalk. We compare terms such as data principal and data fiduciary to their GDPR counterparts, noting that some concepts, like consent manager, have no direct equivalent. Data principal under the DPDPA corresponds to data subject in GDPR, and data fiduciary corresponds to the GDPR controller. Lawful processing requirements show strong alignment. Section 6.1 of the DPDPA requires consent, mapping to GDPR Articles 6 and 7, while subsequent subsections detail the requirements for that consent. Both require valid consent standards, but DPDPA's consent architecture is paired with the consent manager construct. Section 7 of the DPDPA outlines legitimate uses. These clauses, such as state functions and legal compliance, align closely with various provisions in GDPR Article 6. DPDPA consolidates multiple GDPR lawful bases into legitimate uses, reducing granularity but increasing interpretive dependency. Transparency is key. Section 5 of the DPDPA requires notice before or at the time of data collection, mapping to GDPR Articles 12 and 13. Specific rules also dictate the format and accessibility of these notices. The GDPR notice set is more detailed, especially on recipients, international transfers, legal basis, retention, and complaint rights. Section 8 of the DPDPA outlines the obligations of data fiduciaries, which mirror the responsibilities of controllers under GDPR, covering areas like accuracy, purpose limitation, and security safeguards. Data principal rights under Section 11 to 13 provide mechanisms for access, correction, and erasure, which generally align with GDPR. Note that some GDPR rights, like portability, are not currently provided in the DPDPA. For children's data, Section 9 sets an age threshold under 18 and mandates verifiable parental consent, aligning with the principles found in GDPR Article 8. Both regulate consent for children, but DPDPA requires verifiable parental consent for under 18 processing. The DPDPA also prohibits certain child-directed practices, which maps only loosely to GDPR's child protection approach under Recital 38 and Article 8. Significant data fiduciaries have specific requirements under Section 10, including appointing a DPO and performing a DPIA, which reflect the risk-based approach utilized in GDPR. The DPDPA's significant data fiduciary model is a uniquely Indian risk classification, rather than a direct copy of GDPR's DPO/DPIA triggers. In the event of a personal data breach, Section 8.6 requires notification to the board and users, aligning with the notification obligations set out in GDPR Articles 33 and 34. GDPR is more specific on records of processing activities and breach notification thresholds, while DPDPA's rule set emphasizes reasonable safeguards and notification mechanics. Cross-border data transfers are managed under Section 16, which permits transfers to notified countries, similar to the adequacy decision framework found in GDPR Article 45. Both regulate international transfers, but the mechanisms differ fundamentally. GDPR uses adequacy decisions and transfer tools like SCCs and BCRs, while DPDPA currently relies on government-prescribed restrictions and conditions. The exemptions framework under Section 17 provides for specific situations, such as state functions and legal claims, which are also accommodated through various provisions within the GDPR. Moving on to our governance and regulatory structure, Section 18 establishes the Data Protection Board, mirroring the independent supervisory authorities found in GDPR Articles 51 and 52. Both create supervisory enforcement structures, complaints, appeals, and penalties. The exact institutional design differs, since DPDPA establishes the Data Protection Board of India rather than an EU-style supervisory authority network. Next, let's look at consent managers. This is a concept unique to the DPDPA framework. Sections 6.7 through 6.9 define this framework, for which there is no direct equivalent in the GDPR. The DPDP rules further refine the requirements for consent managers, including registration and audit standards, showing partial alignment with broader accountability principles in other regulations. On data retention and erasure, Section 8.3 and 8.8 dictate retention limitation and the obligation to erase data. These correspond to GDPR Articles 5, 1E, and 17, respectively. The DPDP retention rules define specific timelines and sector-specific norms, mapping closely to the storage limitation and member state laws acknowledged by the GDPR. While the DPDPA is principle-aligned with the GDPR, it offers a streamlined approach with a focus on consent-centric architecture and centralized enforcement. When examining structural gaps, we note that features like data portability, the right to object, and explicit protections against automated decision-making are currently missing in the DPDPA, unlike in the GDPR. Conversely, the DPDPA streamlines certain concepts, such as compressing lawful bases into consent and legitimate uses, and places a stronger emphasis on centralized enforcement and child protection. When adapting your compliance strategy, remember that your existing GDPR investments provide a strong foundation, but you must shift focus to a more consent-heavy architecture and integrate with the consent manager ecosystem. You can build upon your existing DPIA, ROPA, and DPO structures to adapt to the DPDPA's consent-heavy architecture. In conclusion, granular mapping shows that while the conceptual overlap is significant, the operational implementation differs. Organizations should focus on translating GDPR rigor into DPDPA simplicity. GDPR is the broader, more mature risk and rights framework. DPDPA is a leaner, India-specific consent and obligation model with a few unique governance features. If you are interested in trying out the DPDP Act provisions, you can use the Consent Manager Simulation Portal at myconsentmanager.co.in to test your integrations as a data fiduciary or data principal. We recommend the CalPI Quiz app, available on the Google Play Store, to test your knowledge of cybersecurity, the DPDP Act, and other important topics. The app offers various levels of difficulty and interactive assessments to improve your awareness. Thank you for watching this video relating to mapping DPDPA sections versus GDPA articles. Hope you now know more about GDPA and how they compare to DPDPA. This was the 34th video in this series, released by DPDPAmentor.in. Please visit our YouTube channel, DPDPA Mentor, as well as our website, dpdpamentor.in, regularly to check out other informative resources. Wishing you a successful DPDP Act implementation.